Start. Para. This is a petition under Section 166 of Motor Vehicles Act for grant of just compensation. Brief facts giving rise to this petition can be narrated as follows. Para. Petitioner was 46 years old and auto rickshaw driver at the time of the accident. He was earning rupees 10,000 per month by plying auto rickshaw on 28/6/2016. He was plying his auto rickshaw and was proceeding towards Khar from Kalina railway station with passengers. When he reached in front of gate of Mumbai University, a car came from front side to enter the gate of University in a high speed and dash forcefully against the auto rickshaw of the petitioner, in which he had sustained multiple grievous injuries. He was rushed to the KEM hospital. He had sustained multiple fractures and was admitted. He had undergone the operation in the form of ORIF with K-wire and plating to both legs. Due to the injuries sustained by him, he had sustained permanent partial disability to the extent of 49%. He was required to undergo further treatment. Hence, this petition for grant of compensation for the personal injuries sustained by him of rupees 10 lakhs with future interest 18% per annum from the date of petition till realization of entire claim amount. Para. Opposite party files its written statement of defense at Exhibit 16 and inter alia denied all the adverse averments made by the petitioner. It is contended that, in fact, the petitioner was plying his auto rickshaw in a high speed, in a rash and negligent manner, and was responsible for the accident. She was neither rash nor negligent, and therefore not liable to pay any compensation. Alternatively, she had claimed that if this tribunal comes to the conclusion that she was rash and negligent, even then, on the relevant date and time, the offending car was duly insured under the insurance policy, and it was valid up to 5/10/2016. On these lines, she has prayed for dismissal of the petition. Para. Insurer filed its written statement of defense at Exhibit 14 and inter alia denied all the adverse averments made by the petitioner. It is contended that two vehicles were involved in the accident. However, the petitioner did not array owner and insurer of the another vehicle, that is auto rickshaw, and therefore claim petition is bad for non-joinder of necessary parties. It is further contended that petitioner did not sustain any permanent partial disability resulting in functional disability. On these lines, insurer has prayed for dismissal of the claim petition. Para. I have gone through oral as well as documentary evidence on record. I have also considered rival arguments advanced by the parties. Let me decide whether the petitioner proves that offending vehicle was involved in the accident and its driver was rash and negligent and responsible for the accident. In a proceeding under Section 166 of the Motor Vehicles Act, a petition is duty bound to prove aforesaid twin tests. Petitioner in his substantive evidence stated that when he was in front of the university gate, the offending car came from front side in a rash and negligent manner and dashed auto rickshaw, in which he had sustained multiple injuries. He has produced on record certified copy of FIR (Exhibit 21) and spot Panchanama (Exhibit 22). It appears that spot of incident is situated in front of northern gate of the university on South-North Western Express Highway. It seems that on FIR of petitioner CR number 152/16, punishable 279 338 of IPC, came to be registered against driver of the motor car, though the opposite party come with a plea that in fact the petitioner was rash and negligent and responsible for the accident. However, she did not enter into the witness box to substantiate her claim. Therefore, adverse inference is required to be drawn against her that stand taken by her in her written statement of defense is incorrect. Even the insurer did not take pain to examine the car driver before this tribunal to show that petitioner was rash and negligent or contributed for the accident. It is not the case of the opposite party that after investigation she was exonerated from the charges by the investigation agency. Considering the aforesaid facts and circumstances, I have no reservation to say that petitioner has proved that opposite party drove her car rashly and negligently and caused injuries to the petitioner.